The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon and welcome to the docket of the Kansas Supreme Court. I'd like to welcome everyone both on the call as well as those who are watching on our Supreme Court Live channel. I would also like to introduce and welcome our visiting judge today. Judge Bruce Brown is joining us. Judge Brown is sitting in the seat vacated by the recent retirement of Justice Carol Beyer. Judge Brown is a district court judge in the 18th Judicial District in Sedgwick County, Wichita, and he has served in that position since January of 2009. Judge Brown, we are thankful that you have been willing to take time from your own docket to help us today, and we are honored to have you join us.
Thank you, Chief Justice.
Certainly. With that, I would now ask Mr. Doug Shima, the clerk of the appellate court, to call this afternoon's 1:30 docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Monday, October 26, 2020 consists of two cases. The first case is appeal number 122867 in the matter of Adebayo I. Ogunmeno, original action in attorney discipline, no briefs filed. The second case is appeal number 122332 in the matter of Amy J. Ahrens, original action in attorney discipline, no briefs filed. For the first case, the disciplinary administrator has reserved 2 minutes time for rebuttal. Your Honor, we are ready to proceed with appeal number 122867 in the matter of Ogunmeno.
Thank you, Mr. Shima. I would ask now that you please enter your appearances.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office.
Mr. Ogunmeno, go ahead if you would enter your appearance, please.
May it please the court, this is, my name is Adebayo Ogunmeno.
Mr. Vogelsberg, you may begin your argument.
Thank you. This is an original proceeding in attorney discipline involving attorney Mr. Adebayo Ogunmeno. Mr. Ogunmeno was admitted to the Kansas bar in 1991. Sometime in June of 2018, Mr. Ogunmeno left the United States and went to Nigeria. At the time that he left the country, he had 4 legal matters that were either pending against himself personally or pending against his clients. First, he had an appeal pending before the 10th Circuit where he was challenging Federal District Court Judge Julie Robinson's decision to personally sanction him for violating Federal Rule 11. In August of 2018, the 10th Circuit affirmed Judge Robinson's decision. Second, Mr. Ogunmeno had an appeal pending before the Kansas Court of Appeals where he was challenging a judgment of $38,800 against him for legal malpractice. Mr. Ogunmeno failed to appear for oral arguments that were scheduled in April of 2019. The Court of Appeals ultimately affirmed that judgment. Third, Mr. Ogunmeno began representing client PF in June of 2017 in an already pending probate matter involving PF's uncle's estate. Mr. Ogunmeno was advanced $10,000 to perform work in that case. When Mr. Ogunmeno left the country in June of 2018, the probate case was still pending. Mr. Ogunmeno failed to timely respond to PF's request for information about her case and abandoned her as a client. Finally, Mr. Ogunmeno was representing client RCM in 2 criminal cases in Johnson County District Court. The parents of RCM paid Mr. Ogunmeno $12,000 to represent their son. After leaving the country, Mr. Ogunmeno failed to attend motions hearings and a jury trial that was scheduled in August of 2018. Mr. Ogunmeno abandoned RCM as his client, causing delay in his criminal case. The matters I just described resulted in formal charges being instituted against Mr. Ogunmeno and a hearing originally scheduled for March 20th, 2019. On March 4th, Mr. Ogunmeno filed a motion to continue that hearing, noting that he was in Nigeria and not expected to return to the United States until mid-November of 2019. Mr. Ogunmeno requested that the hearing be scheduled for the first week of December 2019. Based on Mr. Ogunmeno's request, the hearing panel granted his motion and the hearing was rescheduled for December 5th, 2019. In anticipation of the December 5th hearing, the Disciplinary Administrator's Office filed an amended notice of hearing and an amended formal complaint. In compliance with Supreme Court Rule 215, these pleadings were sent by certified mail to Mr. Ogunmeno's addresses that he had with attorney registration. The mailings were ultimately returned to the Disciplinary Administrator's Office as undeliverable and unable to forward. In October 2019, this court issued an order administratively suspending Mr. Ogunmeno for failing to comply with the annual CLE requirements. In November 2019, Mr. Ogunmeno exchanged emails with former Deputy Disciplinary Administrator Penny Moylan regarding his need to file a motion requesting a continuance of the December 2019 hearing. Despite telling Ms. Moylan he would, Mr. Ogunmeno never filed a motion requesting a continuance and never provided a current address to the Disciplinary Administrator's Office. Ultimately, Mr. Ogunmeno failed to attend his disciplinary hearing after the Disciplinary Administrator's Office put on evidence establishing that he had complied with Supreme Court Rule 215 to achieve service upon Mr. Ogunmeno. The Disciplinary Administrator's Office put on evidence of Mr. Ogunmeno's conduct, and at the conclusion of the hearing, recommended that he be disbarred. The hearing panel later issued a report on March 23rd, 2020, that Mr. Ogunmeno's conduct violated 1.1 competence, 1.3 diligence, 1.4 communication, 1.16d termination of representation, 3.1 meritorious claims and contentions, 3.2 failure to expedite litigation, 3.3A3 canter to the tribunal, 3.4C fairness to opposing counsel, 8.1B failure to cooperate in a disciplinary investigation, 8.4C engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation, 8.4D engaging in conduct as prejudicial to the administration of justice, Rule 208C, failure to notify the clerk of the appellate court of a change of address within 30 days, and Rule 211B, failing to file an answer to a formal complaint. Based on these rule violations and several aggravating factors, the hearing panel recommended that Mr. Ogunmeno be disbarred. Mr. Ogunmeno ultimately never filed any exceptions to the hearing panel report. Accordingly, the findings are now deemed admitted. Based on the serious misconduct I outlined that resulted in 5 separate disciplinary complaints being docketed against Mr. Ogunmeno, the Disciplinary Administrator's Office is still recommending that he be disbarred. That concludes my prepared argument for today. I would be more than happy to take any questions from the members of the court regarding this conduct. But again, the Disciplinary Administrator's Office is continuing to recommend that Mr. Ogunmeno be disbarred.
Are there any questions for Mr. Vogelsberg? Thank you. Mr. Ogunmeno, you have 15 minutes to address the court if you wish.
Yes, may it please the court. As I speak, I'm still speaking from Nigeria. I've responded to the written responses. I believe they say some of them are late and I requested. At the time, I was sick and I advised who was investigating, but I've submitted all my responses. I believe it's in the record, and I ask that the court review the record, and I commend my responses to the court. I believe the sanction, the disciplinary action administrator is asking for is too extreme, and I ask that my license is already suspended because I did not do registration. While I was in Nigeria, I was sick intermittently, but I'm okay now. I'm still in Nigeria now because I can't return. There is trouble and the airport is closed. But now I'm appearing via video. I'm asking that my license be reinstated, not it's suspended now, but be reinstated. That's all I have, Your Honor. Thank you very much.
All right. We do have the record of the case before us. Are there any questions?
Have you done anything to try to address the legal matters that you abandoned when you left the country?
Well, I have the responses. I've responded to them in my written response. I didn't abandon those cases, but when those things, information were coming in, that was the time I was very sick, and I talked to the client. I think I sent them some emails. Some of the email were attached to my response. And the report they said that I didn't respond to. I didn't get the report until I think Friday of this week. Yeah, I know that there was a problem with filing a new address in the United States. But when I went to the website, I didn't get access to it. I couldn't file it. I have to send email at one time. I think that's how they get the new address I supplied to them.
There are other questions? Mr. Vogelsberg, I believe you reserved 2 minutes.
Unless the court has any additional questions for me, I would go ahead and waive rebuttal at this time.
I have a quick question, and it has to do with what we just heard about at least an alleged failure of delivery of what I assume is the hearing report.
I'm sorry, Justice Stiegel. I didn't catch your question. There was a little bit of audio interference.
I'm sorry. I just wanted to get the disciplinary administrator's response to the claim that the hearing report was not received until this week.
The hearing panel report came out on March 23rd, and because of that time with COVID, there was a delay in preparing the record to be submitted to the court. But on April 30th, I can announce this as an officer of the court. On April 30th, my office emailed a copy of the hearing panel report to Mr. Ogunmeno at that time. And then ultimately, this court ordered in June that the 20-day period for Mr. Ogunmeno to file exceptions to the hearing report began to run or start at that time. And within that time period, he never did file any exceptions to the hearing panel report.
And the only way that we can conclude that he had service of the report is from the email. I guess what I'm driving at is whether or not exceptions were filed is pretty significant with respect to whether or not we accept the findings of the panel.
Right. I guess what I would say is Mr. Ogunmeno under Rule 208C had a duty to update attorney registration and provide addresses in which he could be served with pleadings. By his own admission, he had been out of the country for 2 years and he failed to ever update or provide any addresses. And so that was the only addresses that the clerk's office had to serve him with the citation and the hearing panel report. Again, on April 30th, my office did serve him, or I mean, as best as we could. The only way that we had information that we could reach him was through a Yahoo email address. That's in the record, I believe at exhibits 33, 50, and 51. There's evidence that he was using this Yahoo email address to contact Miss Moylan and talk to her. And that was back in October of 2019. And that was the only way that we had to communicate with him. And so on April 30th, that was how we served the hearing panel report, was through that email address.
From the perspective of your office, is there any merit in the idea that now that we have Mr. Ogunmeno with us, he could be provided an opportunity to make a response to the hearing panel report?
I believe he's already had that opportunity. What he could have done during the 20-day exceptions, which he did receive notice of, is that he could have requested an extension of the deadline for filing.
I guess cutting to the chase, your office would oppose any such suggestion.
Yes.
There are other questions? Okay, I would thank both of you for your arguments. The court will take this case under advisement. That brings us now to the hearing of our next case in 112332.
Madam Chief Justice, we will get the attorneys into the hearing.
All right, thank you, Mr. Shima.
Mr. Ambrosio, can I get a sound check quickly?
Mr. Kuma, are we done? This is Ogunmeno talking.
Yeah, yes.
Mr. Ambrosio?
Yes, Mr. Clerk.
Mrs. Ahrens
Good morning.
and Mr. West.
Morning, Mr. Shima.
The second case for the 1:30 p.m. docket is appeal number 122332 in the matter of Amy J. Ahrens, original action and attorney discipline. The disciplinary administrator has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Would you please state your appearances?
May it please the court, your honors, Gary West appears on behalf of the Office of the Disciplinary Administrator.
Okay, please the court. The respondent appears in person by John Ambrosio. We are ready for argument.
Thank you, counsel. Mr. West, you may proceed with your argument.
Thank you, your honors. The hearing panel found that the respondent in 3 separate interviews to 3 different law enforcement officers lied about her knowledge regarding her then boyfriend's involvement in selling drugs. The first 2 occurred in July of 2016 after a traffic stop. The traffic stop resulted in the seizure of $22,000 in cash and 58 grams of marijuana. The third interview occurred 2 months later in Topeka, where the respondent continued with the same lie until the detective confronted the respondent with evidence of the truth that the respondent had been present during her then boyfriend selling drugs. At that time, the respondent came clean. The respondent was charged out of Lincoln County, Kansas, with possession with intent to distribute a level 3 drug felony. A level 3 drug felony, regardless of a person's criminal history score, would land them in a presumptive prison box on the sentencing guidelines. The respondent cooperated with law enforcement in the investigation of her then boyfriend. The case out of Lincoln County was dismissed. The hearing panel concluded that the actions of the respondent violated Kansas Rules of Professional Conduct 8.4 C, D, and G. The other violations found by the hearing panel resulted from a separate case. In that case, the investigation concluded there was a lack of probable cause to support the complaint. However, the respondent failed to reply to any communications from the Office of the Disciplinary Administrator and failed to cooperate in the investigation. The hearing panel concluded that these actions resulted in a violation of KRPC 8.1 and Supreme Court Rule 207. No exceptions were taken from these findings. The actions of the respondent violated her duty to her profession, to the judicial system, and to the public at large. As officers of the court, lawyers must abide by the rules that shape the administration of justice. One such basic rule is that all citizens must be honest when answering questions posed by law enforcement. Thus, by lying to law enforcement, the respondent breached a basic duty to the administration of justice. By failing to reply to the Office of the Disciplinary Administrator or to cooperate in the investigation of the second complaint, the respondent violated her duty owed to the profession. And by lying to law enforcement, she violated her duty to the public by failing to maintain her personal integrity. The mental state in which the respondent acted when committing these acts was knowingly. The respondent, by lying to law enforcement, acted with a conscious awareness of the untruthfulness of her statements and the attendant circumstances. Thus, the respondent acted knowingly. Injury did occur. By lying to the law enforcement, respondent caused injury to not only our profession, her profession, to the legal system, and to the public at large. These were the duties violated. There were aggravating circumstances and several mitigating factors. The aggravating factors are that the respondent acted with dishonest and selfish motive when repeatedly lying to law enforcement. She did this in an effort to avoid getting in trouble. This reflects poor judgment and a lack of credibility. The respondent obstructed the disciplinary process when failing to reply or engage in the investigation. This would be an aggravating circumstance. And the respondent's use of controlled substance would also be an aggravating circumstance as well as a mitigating circumstance. The mitigating factors are that the respondent has no prior disciplinary history. The respondent had personal and emotional problems that she was facing. The respondent's most ardent supporter and confidant had been her mother. Her mother had passed away from cancer while she was in law school. The respondent at the time of these actions was suffering from depression and anxiety. The psychotherapist in her report indicated that the respondent was both dependent and scared of her then boyfriend, which could provide some explanation as to why she found herself in that circumstances and could not extract herself from those circumstances. The respondent was a new lawyer. She had only been practicing between 3 and 4 years. This would be a mitigating circumstances. However, in spite of the fact that she'd only been practicing for 3 to 4 years, she had developed a very good reputation within the Leavenworth County Bar. They describe her as bright and capable attorney, an attorney who was prepared, and an attorney who was well liked within the bar. And at the hearing in this matter, the respondent expressed genuine remorse and has taken steps to improve herself. The ABA standard, which applies to the actions of the respondent in this matter, which is applicable to her actions, is ABA standard 5.12. This standard states that suspension is generally appropriate when a lawyer knowingly engages in criminal conduct that adversely reflects on the lawyer's fitness to practice. The respondent's actions in this matter fall squarely into this standard. The hearing panel recommended an indefinite suspension. That is also the recommendation of the disciplinary administrator, and that would be our recommendation today. Thank you very much.
And Mr. West, is the disciplinary administrator still stand for the position that the suspension should not be made retroactive?
Well, I would say in response to that, that I would, in rebuttal, I might have an opinion regarding that. I always want to wait and see what Mr. Ambrosio presented, what has happened in the time period since the panel hearing. I would state if things have continued like I suspect they have continued, our office wouldn't object to the suspension running from the panel hearing. I suspect Mr. Ambrosio wants it to run further back. I didn't state that the respondent's license was administratively suspended back in 2017.
All right. We'll let you address my question in rebuttal then.
Thank you, Your Honor.
Are there other questions? Mr. Ambrosio?
Thank you. Madam Chief Justice, Your Honors, may it please the court. And my client would like to address you at the conclusion of my talk in regard to this matter. At the outset, let me say that there is no doubt that the facts described in the panel report and the conclusions of law were dead on and accurate. We understand the recommendation of the panel and their indication of what disciplinary rules were violated. We understand and agree that she should be suspended. The question is, how long should that suspension be? We understand it should be indefinite. We agree with that because she's working on her program. However, we believe it should be retroactive back to October 31st, 2017, when she was administratively suspended because she didn't do CLE, she didn't pay her fees, etc. This has been a work in progress for this young woman who is bright, she is smart, and she has a good future. The question probably all of you are asking is, how do bright, smart, educated people get in this situation? And I think I'm not smart enough to understand why PTSD hits. I'm not smart enough to understand a lot about psychological background, but it was described in the panel report on page 18 in paragraph B. Dr. Higginbottom, who testified in this case from Denver, she is the therapist now involved with my client, indicates that she is not currently, at that time, ready or fit to practice, that she wouldn't be ready for about 18 months, and only if she worked her program, dealt with therapy, stayed off drug and alcohol, and continued to work her program. What my client wants to do is she knows she's going to have a hearing once she's suspended. She's going to have a hearing to determine if she is ready to come back into the practice, and we'll have to present the evidence that will show that she has worked her program. Then, if she gets her license back here at some later time, she then wants to work and practice in Colorado, which she currently lives with the father of her child and her 2 kids. She has been working through 2 pregnancies. She continued in therapy. COVID stopped it a little bit, and the cesarean section led her to be bedridden for quite some time. She's ready to start practicing again as far as meeting with her therapist. She is working in a sales position. She is working hard to support her family while the gentleman she's with acts as a house husband. She lives in Colorado. She'll continue to go to therapy. She wants to work with KLAP, and she also is starting to work with the same group that is in Colorado as far as having a mentor, as far as having somebody work with her as she gets through the problems she has had with drug abuse and the problems that are described in paragraph 14. This is a young woman who needs a chance again. She will admit to you, as she did to the panel and to Mr. West, that she made major mistakes. She got involved with an individual who told her what to do, abused her, and she was afraid of him. I understand that that's not always an excuse, but it was bad for her to do so. She allowed him and attended on 3 occasions where he sold marijuana, and she should have known better than that. And maybe she should have run. But it is my understanding from talking to Dr. Higginbottom and other psychologists and psychiatrists, sometimes it's difficult for a woman, or maybe a man for that matter, to get out of those relationships. Once she was stopped on her way back from Colorado with this gentleman, she realized how bad the situation was. She panicked. And Mr. West is absolutely correct. She panicked. She lied to law enforcement. Maybe what she should have just done was fived up, and this would have ended, and then she could have gotten a lawyer and dealt with those problems. She chose not to do that because of what is described in paragraph B on page 14. She is on her way to recovery. She's not using. She is living with her family. She's doing everything possible to change her life. She will work with Dr. Higginbottom until Dr. Higginbottom indicates that she is ready to practice. So what we're asking for is that it be retroactive, at least to the hearing, and maybe even further than that since she hasn't been practicing. That's all that I have at this time. With the court's permission, my client, Your Honor, would like to address the court.
Well, first, are there any questions for Mr. Ambrosio?
I have a question about dates. Both parties are suggesting indefinite suspension. You have asked that it begin from the date of the administrative suspension in October of 2017.
That is correct, Your Honor.
It would appear from at least some objective appearances that the downward spiral that your client was in was continuing at that time. When would you say that she seriously and unequivocally turned things around in an alternative to that date?
I don't want to pat myself on the back, but I believe this when I got involved, which would have been, according to the panel hearing, sometime in June 2 years ago. I believe I'm correct on that. Not that I'm patting myself on the back, but then she got involved with Dr. Higginbottom. She got into KLAP at the time when I got involved. And the panel indicated when I get involved, but I don't see it in my notes. I trust I've answered your question. And then the spiral, she leveled out at that point, and she's been working, Your Honor, on this since that time.
Other questions? Ms. Ahrens, if you would like to address the court, you're certainly welcome to. You still are on mute, though.
Thank you.
Sure. We do that all the time.
Good afternoon. Thank you for taking the time to hear my case and allowing me this opportunity to speak in front of you all. I know that I'm responsible for my past mistakes, and it is those mistakes which bring us to these proceedings today, and for that I'm truly sorry. I passed the bar at the end of 2012 and began my own law practice in Leavenworth, Kansas shortly thereafter. By 2014, at the age of 27, I had a well-established general practice law firm where I focused on criminal defense and family matters. I was young and had already achieved my lifelong dream of becoming a criminal defense attorney. My family and peers had all expressed pride in my success, and it became especially important to me to maintain this impression, even to the point of my own detriment. Unbeknownst to most of my peers, I was battling heavy depression through law school and early on in my professional career. This was brought on by primarily two factors in my life. The early death of my mother while in law school, and the subsequent isolation felt while completing school in Kansas after her passing, far away from friends and family back home in Colorado. These factors, coupled with the detrimental desire to maintain a perfect appearance with my family and peers, led me to make some bad decisions. In early 2016, the romantic relationship I was involved in had driven me from maintaining relationships with all but a few fellow attorneys during my workdays. I had cut much of my support structure out, and I became increasingly reliant upon my partner to replace friends and family, an obvious mistake looking back, but not so apparent at the time. By June 2016, I realized that I needed out of the relationship I was in, and I needed to move back home to Colorado to be home with family and friends who could support me. The truth was that I had been involved with someone whom I suspected was breaking the law, but I couldn't find myself to leave him. I was so scared and isolated and maybe a little too proud to seek help. It was foolish. Shutting others out helped make it easier for me to rationalize my relationship. Additionally, the less my family and friends knew, the easier it was for me to maintain my image of success that I believed was so important for me to maintain with them. I had too much pride to realize I needed to ask for help, and also scared that ending the relationship would expose my failings. I look back on that time with so much regret. Had those years in law school away from my family and my mother been for nothing? In the years since my arrest, I have been filled with so much anxiety over having indeed ruined my career before it ever even really had a chance to begin. I do thank God every day for my arrest, however. It has given me a new beginning. Do not misunderstand, the arrest was not my turnaround point, but merely a speed bump to the road to rock bottom, and I've spent the last 4 years climbing out. I moved back to Colorado in 2016 and lived with my dad and stepmother, who have been instrumental in supporting me. They gave me a place to live while I battled my issues. Upon first moving back, I was still in a dark place. I didn't know what was going to happen, and everything that I had worked for my entire life felt like it was slipping through my fingers at a moment's notice. I didn't know how to get in control of anything. I didn't know where to start, and part of me didn't even know if I cared enough to even try. At one point, I was living couch to couch and just hoping that I would have somewhere to stay that night. I had finally started a job in sales at a company near Denver that gave me an even greater sense of family. Day by day, I felt myself slowly coming to life again. I became involved with a much kinder and supportive gentleman named Jay. He became my confidant, and we worked equally in the relationship to support each other and ourselves. I became pregnant with our first child, Lonnie, who was born in May 2019. It was at that time that my first disciplinary hearing was scheduled. And up until then, I had been putting all my disciplinary issues to the side, because even at that point, the thought of losing my career was so unimaginable to me. It was too overwhelming to handle, so I just didn't. Not until my son was born, which lit a spark in me and gave me the strength and motivation to tackle my past mistakes directly. I contacted Mr. Ambrosio a week after I got out of the hospital from delivering my son and asked him to take my case on such short notice. That same week, I was back in therapy and was talking about my past transgressions for the first time since telling my family in 2016 why I was no longer practicing law. Therapy is something I know is crucial for me. It is a safe place where I can process my emotions and stay focused on my mental health. I have reestablished my relationships here with family in Colorado, especially my sister, all of whom have provided overwhelming support in the midst of all my mistakes. When all of this started, I was in my late 20s. I was a new attorney living in a new state with no family near. In fact, when I look back at those days, I don't even recognize that woman, as I feel like a completely different person today. I failed miserably by not reaching out for help sooner and leaving that relationship, and I fully accept responsibility for my situation. Today, I'm in my 30s with a husband and 2 children, a 1-year-old boy and a 6-week-old baby girl. I live for them, my family. All I want is to be the best role model to them and take charge of my past mistakes. I've never lost sight of the fact that what I risked and lost was huge and has put my future opportunities in jeopardy. It took some years and growing my own family to realize this. It is a privilege to practice law, and I believe that I will be an asset more now to our legal community. I appreciate the opportunity to speak before you today and beg for the court's mercy to be able to practice law in the near future so that I may excel in a career that I am so deeply passionate about. Thank you.
To answer Justice Wilson's question, recovery started, I believe, July of 2019. Sorry for interrupting.
And what is the, Mr. Ambrosio and Ms. Ahrens, you referred to a program that you're doing or engaged in. Can you describe that for me? And I appreciate you have a 6-week-old, and that might be causing a little disruption in that, but tell me what you're doing.
I meet with Ms. Higginbotham. She's my therapist, and I meet with her once. Well, I had been meeting with her every other week.
Is there any other, Mr. Ambrosio mentioned KLAP, and then I know that there's a Colorado assistance program. Are you doing anything with them?
At this time, I've met with COLAP, and they're kind of on standby. They kind of wait for a recommendation from the court in order to get involved with their program from out of state, is my understanding.
Ms. Ahrens, when would you say yourself that you seriously started to turn things around with regard to your recovery and trying to get keep your license?
I would say that would be either May or June of 2019. It was around that time period. It was right after I had my son.
Other questions? Anything else from Mr. Ambrosio?
No, Your Honor, that's our submission. Thank you.
All right. Mr. West, you did reserve 3 minutes.
I don't think I need to use my 3 minutes, Your Honor. Mr. Ambrosio is correct about the time frame for when things started to change. Ms. Higginbotham's report covers the time period from July of 2019 to November of 2019. And in her report, she stated that she thought it would be 18 to 24 months before the respondent would be able to start limitedly practicing law again. That would be my only rebuttal. Thank you.
Any questions for counsel?
So that I'm clear, Mr. West, then you are suggesting that the indefinite suspension should begin when the Supreme Court makes its decision?
I think running the suspension from the date of the panel hearing would be appropriate.
Okay, and why do you believe that date is more appropriate than the date suggested by Mr. Ambrosio?
I think the conduct was extremely serious conduct. I'm confident that respondent is making strides to improve herself. I just think that that would be a more appropriate date than going back to July of 2019. The treatment report of Dr. Higginbotham covered a period ending in November of 2019. I think that date could be appropriate.
Mr. Ambrosio, why do you think the date of October of 2017, the date of the administrative suspension, is more appropriate in this case?
I think she started at that point to realize how bad things were. But I'm reconfiguring as I listen to the arguments of my counsel on the other side, and I listen to Amy, and I also reread everything that was in front of me. And maybe it would be smarter to start 2 years after that, or July 2019, when my client really turned the corner, although I hate to use that term, when she changed her lifestyle, when she stopped using drugs, when she was out of this area, and when she really started to work with KLAP and now COLAP. That's my rationale. It looks physical. I hope I've answered your question.
Yes, thank you.
Are there other questions? Thank you, all of you, for your arguments today. The court will take this matter under advisement. Court is now recessed.